Good morning. Welcome to this morning's webinar, A Primer on Civil Litigation, How to Avoid Getting Sued and What to Do if you do. My name is Mark Koerner. I'm a senior attorney with Foster, Swift, Collins, and Smith. Before we begin, I need to go through just a little bit of housekeeping. We are recording this session, and we will email a link to the webinar to the address you registered for this session with today later on in the afternoon. It will also be available at Foster Swift's website on the video and coronavirus resource page. We do have a question and answer session enabled this afternoon, but because I have a lot of material, we're going to go through and present the material first. And once I'm done presenting the material, we'll hopefully I'll do the best I can to answer all your questions once that's complete. First, just a little bit about myself. I started practicing law in 2000. I began my career in Chicago as a litigation attorney in a defense practice. And since then, I've had quite a diverse practice. I've been counseling businesses and municipalities with regard to a wide variety of issues, and I'm continuing to litigate cases. Litigating cases has given me a unique perspective on things in that once you're involved in litigation, you're essentially getting to see what went wrong previously that led to litigation to begin with. And because of that, you get a unique idea about what you can do to hopefully prevent getting to the stage where you'd be in litigation in the first place. I'd like to tell you that what I'm going to present to you today is going to ensure that you'll never ever be involved in litigation. Unfortunately, I can't tell you that. There's nothing that you can do to actually prevent someone from suing you. Someone can sue you if they have no basis to do so, but what I am going to provide to you is information to help reduce the risk that you will get sued, and to also give you some information about how to protect yourself so that in the event that you do get sued, you've done what you need to do to put on a defense. So the first thing that you should do in order to avoid getting sued is, sorry about that, is you'll want to hire a good attorney. Now, it's clearly self-serving, but whenever you're working closely with a good attorney, it's likely that you're going to avoid some of the things that could lead you to get sued. The law is complicated, and while an attorney is going to cost money to have them involved in setting up your transactions or working with you on your business, it could save you a lot of money in the long run. Attorneys can review your contracts. They can give you general advice regarding legal ramifications of the actions that you're going to take. And you know, I've worked in litigation with clients that have had some of their documentation prepared by a LegalZoom or Rocket Lawyer. In fact, one instance, a client had an asset purchase agreement prepared by Rocket Lawyer and then utilized that to conduct a sale. And when it wound up in litigation, lo and behold, they didn't have all the information that they needed within that actual agreement, and they hadn't complied with the terms. So it cost them a lot of money in the long run because they were litigating the issue instead of having the attorney with them working through the issues to begin with, so they didn't get into that spot. So again, a self-serving thing, but if you have a good attorney or other good professionals that are working with you, be it CPAs or other professionals, making sure that all your I's are dotted and your T's are crossed is a good way to prevent getting sued in the future. Some of these things, by the way, are going to seem, you know, as common sense rules. Like document everything. Businesses use documents to communicate and transact business and to analyze productivity. But it's really important, especially in times like today, where we've got issues with being on lockdown, employees being in the office, not being in the office. It's very important to document everything that you're doing. You want to document the daily activities by individuals that are properly trained and know how to document to minimize your risk of litigation. Or at the very least, that you'll have documentation on hand if you get sued. You want to make sure that you have all of your contracts put in place, including the contracts between your businesses, contracts or invoices with your customers. Having those organized and documented is good. Any kind of non-disclosure agreements or confidentiality agreements, having those documented, well documented and organized is also good. Any partnership agreement or ownership agreements you have with your partners, also very important to document. Keeping your employment agreements documented if you have employment agreements with your employees. Any of your leases, your permits, your licenses, we want to make sure that's all very well documented. You also want to make sure that you're properly documenting your employee files, making sure that you have them actually documented properly, that the documents are separated properly, meaning that you have, for instance, the medical records are kept in a separate file than the other employee documents, making sure that you've got any kind of disciplinary action or anything else that you have documented as well. You want to make sure that your document is also complete. You don't want to have holes in your documentation. And you also want to make sure that you consistently document things. For instance, with employees, you wouldn't want to make sure that you documented every little thing that I did, but then when Steve, another employee, did the same thing, you didn't document that. So you want to consistently document activities within your business. But ultimately, many disputes can be avoided if you have good documentation, because it adds clarity to what the issue is. And when you have holes in your documentation, it can cause big problems during litigation. Now is also probably a good time to go back through and review your document retention policy to make sure, one, that you're retaining the documents, the timeframes that you're required to by law, and two, just to determine whether or not your document retention policy needs to be updated. So just going back and reviewing that would be good as well. Another way to avoid getting sued is by having good contracts. Obviously, every relationship that you have with another business should be governed by a written contract. And frankly, that written contract should be reviewed by an attorney each and every time. During this pandemic, what we'd also suggest is that you go back and review the contracts that you currently have. One, to ensure that you're doing what you're supposed to be doing, doing what you've agreed to be doing within the contract, and two, to determine if you have provisions in the contracts that you currently have that could potentially protect you from liability for non-performance on the contract. For instance, do your current contracts have a force majeure clause? And the force majeure clause is basically, it excuses a party's non-performance based upon catastrophes, acts of God, wars, and strikes. They're written in several different ways. But it is a feature that could potentially protect you from non-performance. Now, it wouldn't generally protect you from non-performance due to an illness outbreak. However, we're not sure whether everything is going to go with that based upon the existing status of the coronavirus. There are other terms aside from the force majeure clause that you'd want to see if you have in your contracts that will also excuse non-performance. Those include, excuse me. Forgive me for looking at my notes on occasion, but those other contract clauses will include illegality, impossibility, impracticability, frustration of purpose. There are other clauses that if you have them in your contracts, they can ultimately protect you if you are sued. And they can protect you in the event that before you're sued, if you're dealing with somebody that's claiming that you're non-performing on a contract, you can say, well, I have this clause. It excuses my liability for that. Let's figure out what to do rather than going into litigation. You also, and I say reviewing your contracts to see if you have these clauses, but also in the new contracts that you develop or enter into with other parties, you want to make sure that these clauses are in your contract, just so that if you run into an event where you can't perform pursuant to whatever reason, now that we're dealing with the coronavirus, that you have those provisions in your contract. There are other contractual clauses that you can use to shift risk to avoid litigation. There are cure provisions, meaning that if you don't do something you're supposed to do in the contract, the other party is required to give you notice that you've not done it and give you an option to cure that defect. There are mandatory mediation and arbitration provisions, which would prohibit it doesn't prohibit the filing of suit within the circuit court. However, it would allow you to actually move the court to dismiss and return the matter to mediation or arbitration. There are also risk shifting clauses that you'll want to include in contracts in the event that you are sued. There are indemnity provisions where you can require the other party to indemnify you and hold you harmless in the event that you're sued. You can request that you be included as an additional insured on someone else's policy of insurance, so that if you do get sued, someone else's insurance is on the hook for covering that defense. And there's also release and disclaimer language that you want to make sure that you have included in your contracts, depending on the type of contract that you're involved in. And again, when I said to review your contracts, another thing that really makes sense in this time is to go back through and review your contracts to see where you're at with what you've agreed to do, to make sure that there's nothing that you need to get out ahead of. If there's something in a contract that you haven't been able to comply with, reaching out to the parties that you're involved in that contract with and discussing it, seeing if there are ways to rectify whatever it may be prior to them filing suit is a good idea. You want to be careful and generally get your attorneys involved if you know that that's going on, so that you don't make an admission that could otherwise come back to haunt you if you do get sued. But having those discussions in the first instance is most of the time a good thing. During this time, you want to make sure that you're making calculated decisions. You want to make sure that you can justify the decisions that you're making in the future if called to question on those decisions. For instance, if we're to have another surge of the coronavirus and you decide that because of a slack in business, you need to lay off employees, you need to sit down and determine how it is that you're going to do that, so that you avoid issues where perhaps you lay off a group of people that would otherwise say that you did so in such a fashion because they were elderly and not your younger employees or other protected class. So you want to sit back, even when things are crazy right now, the coronavirus, you want to sit back and make sure that you're taking time to make the decisions that you're making and working through those decisions, be them tax decisions, financial decisions, or legal decisions, with professionals to avoid getting sued in the end. You also, as I said, document everything. So it's changed, the coronavirus has changed the speed at which we make decisions. So you want to take your time to make those decisions, but also document those decisions so that later on, in the event that you do get sued, for whatever reason, you have the ability to go back, look at the documentation you have with regard to the decision you made, and then you can also then prove the reason that you made that decision. That avoids somebody else putting their interpretation of why you made a decision or trying to prove why you made that decision if you have good documentation of why you actually did it. For instance, if you, in the laying off of the employee scenario, you lay off people, you decide that you're going to lay off people with the least seniority first, and then move your way up to the people with the most seniority. You do that, you document that. It turns out that, the first two people that are laid off are elderly, and then come back later on and make a claim that it was age discrimination, that you filed, that you laid them off first because of their age rather than any other policy. And the response is, you've got a documentation now that shows that you decided, you took time, you made the decision to lay off people in order of the time they've been with the company. You've documented that decision. You've documented the fact that these two first people that you laid off had the least amount of seniority with the company, and therefore it was not based upon their age, but it was in fact based upon seniority, therefore at least avoiding some liability. Again, you can't necessarily avoid being sued, but you may avoid liability in the event that you are sued. Guidance on lawful and safe reopening of, and it was employer guidance for lawful and safe reopening, and it was presented by Michael Bloom, Carl Butterer, and Cliff Hammond on May 27th. That seminar discussed what physically needs to be done within a physical location to prepare the workplace for employees to return. And it also discussed policies and processes that need to be implemented before employees return. The presentation also talked about what employers can do to minimize the risk of potential liability when they bring their employees back. So it's a very good webinar to watch, and I would suggest that you all do that. Also, with respect to your employees, you want to review the policies and employee handbooks and employee manuals that you currently have to make sure that what you're doing now that we've got different rules and regulations under the coronavirus actually matches what's in your employee manuals. There are new rules about what employees have to be paid if they take time off to care for a child where their school is otherwise closed, whether or not you can require them to use PTO for either part of that or the extended Family Medical and Sick Leave Act. So there's a lot of things that you need to review to make sure that you're not contradicting what it is that you're doing with your employees and what you've got written in your employee manual, even if it means just going back and doing a temporary change to what it is that you have in your employee manual to mimic or at least identify the changes that you've recently made to the things that you're doing, will minimize the risk that you'll get sued. Excuse me. You also want to make sure that you manage and train your employees and the employees that manage other employees, because you can be held liable for the actions of your employees if they're doing the wrong thing. So making sure that you have good training policies and procedures in place will also help to ensure that your employees aren't doing things that are ultimately going to lead you to get sued. So you'll also want to make sure that you protect your data. As people have been working from home, there have been a lot more times that people have been utilizing computers and other electronic equipment to tunnel into corporate data so that people can successfully work from home and manage their work responsibilities without being in the office. And now we're currently in stages of allowing people to return to work. However, a lot of businesses are still keeping some, if not all, their employees that are able to work from home, working from home. So cyber hackers have learned this and have done a lot, started making a lot more hacks on people to try to get corporate data. So you want to go through and see what kind of policies you have in place to ensure that your people are not subject to cyber attack. So some questions that you should probably ask yourself. Do you have policies in place covering acceptable use and best practices to safeguard your devices being used to conduct corporate work? Prior to the coronavirus, many businesses had policies in place that indicate that you couldn't use your own devices for work, whereas now that employees are working from home, many employees are actually using their own devices. So you want to ensure that whatever your policy says, it isn't contradictory to what's actually taking place. So if you've changed and allow employees to work from home and use their own personal equipment, you should change your policy accordingly. If they're using, if they're using your devices, do you have a plan or procedure in place to update those devices so that they're protected from the most recent malware or other viruses? If they're not using your devices, do your employees know who's allowed to use if they are using your devices, do the employees know who is in their families or who is allowed to use those particular devices? In situations where a person had brought home a corporate computer, allowed their son to use it. The son went to gaming sites and thus opened it up to some virus, which then infected the corporate computers and data was lost. So, advising your employees and having policies on who's allowed to use your equipment is very important. Do you let your employees know where they're allowed to use their devices? Do you have training on making sure that if, they're working from home, but then they decide they're going to go work at a coffee shop because they're allowed to now under the restrictions, that they're using properly secured networks when they're attaching to corporate data? Are there applications that are prohibited for your employees to use? They should be let know that as well. Ultimately, going through your policies and reviewing where things stand with what your employees can and cannot do as it relates to tunneling in to get to corporate data is important to ensure that you don't have breaches. Because again, a breach is a good way, not accurately protecting your customers' data or corporate data is a good way to get breached and then get sued for not adequately protecting it. So protecting the corporate data, and especially in times when you've got employees that are working from home or remote locations, is very important. Don't ignore problems. This seems very common sense, but a lot of litigation could be avoided if people just took what issues were happening head on. What I like to suggest to clients is they create, they work with their own employees and create a reporting system. So you encourage your employees to essentially keep an eye out and evaluate for risk. And if there is something that an employee sees that is a potential risk, that risk is reported back to you as the employer. I'd also suggest that you implement a claim investigation policy so that if an employee reports a potential risk, that an investigation has begun to see what can be done to mitigate that risk. And when I allocate the necessary resources necessary to do that investigation. So, if, for instance, an employee reports that there's a particular problem with a particular contract and the performance under that contract, you identify the particular issues, you interview the people that are involved to see where things stand, and evaluate the potential risk as a result of the information that you learned. A lot of times, reaching out, again, as I said earlier in the presentation, reaching out to someone and saying, we recognize that we have this particular problem. What's a way that we can resolve this problem before things get to litigation is the right way to go. But before making that contact, you want to identify what your anticipated dispute resolution or result is. So if you have an idea of how you think you can solve the issue, you should, if you have that in place before you reach out to the other party, it's always helpful so that you can have those discussions. But also having an idea of things that, if there are things that you're going to have to essentially take a bit of a hit on to avoid a bigger hit of litigation, meaning reduce the amount that you potentially were paid on something or reduce the amount of service that you're providing, any of those things that you can do to prevent the risk of a party suing you will save you money in the long run. You want to adhere to your own policies and procedures. And again, that sounds like common sense, but I know that many of you have been scrambling for the past several months and weeks trying to adhere to all the different executive orders that have been implemented and ensuring that when you do get back to work or your businesses do reopen, that you're doing everything that's required of you by those orders. Something that is problematic is if you go through and you spend the time to develop all those policies and procedures, you put those policies and procedures in place, but then you don't require your employees to follow them. That can be problematic for you in the event that you're sued later. I mean, it's easy to say, I should be protected from liability because I required X, Y, and Z to occur with my employees and with my business. But then in litigation, someone's able to point out that you're not actually enforcing things that you said that you were going to enforce. So therefore, any kind of protection from liability goes out the window. So it's important that if you have a policy that says that we're going to test your temperature every day when you come into the office, that you're going to be required to wear masks in these particular locations, that you actually require your employees to do those things. Again, that's not so much to avoid being sued, but it is more so for protecting yourself from liability in the event that you do get sued. So those are some of the common sense or not so common sense, but the reminders of the things that you should do to try to keep your business protected, keep things running smoothly, and get yourself in a position where you're not going to be faced with potential litigation. So the next question comes, though, you've done everything that you're supposed to do. You've documented everything. You've taken the steps that you need to take to not get sued. So what do you do if you do get sued? And litigation involves uncertainty, and it certainly can be emotional for folks. And many people have not ever stepped foot in a courtroom or have had any idea or have ever been involved in a lawsuit at all. So what I want to do is I want to take the time to outline the process of litigation, let you know the steps that happen in civil litigation, not criminal litigation. We're not discussing that today, but to go through kind of from start to finish how a case would proceed in litigation and give you some general information about how that process works. The first thing that happens is that someone would file a complaint with a court, and then would issue the court would issue a summons, which generally looks like this document, and then they'll have it served upon the defendant of the case. Now we call this the summons and complaint, but really this part's just the summons, and what it provides is it provides the name of the plaintiff, it provides the names of the defendants, it provides the name of the plaintiff's attorneys. If you are personally served with a summons and complaint, you have 21 days in which to file an answer to that complaint. If you're served by mail, you've got 28 days to file an answer. So if a process server shows up at your door or you receive one of these things in the mail, it's very important that the first thing that you do is reach out to your attorney, because the clock starts clicking, and if you don't do the things that you need to do in response to receiving one of these, you can wind up being in a lot of trouble. We'll talk a little bit more about it in detail and later on here in the presentation. Generally, the way that the litigation process works, though, is that the summons and complaint is filed with the court. The defendant in the case is required to file a first responsive pleading. Subsequent to that responsive pleading being filed, there's usually what's called a scheduling conference with the judge, and a scheduling order is issued. Subsequent to the scheduling order, discovery starts, and we'll talk a little bit about what discovery is too along the way. There's time for motion practice throughout the course of the litigation. Generally, alternative dispute resolution is ordered by the court in some form or fashion, be it mediation or arbitration, during the process, usually fairly early on. And then you have ultimately a trial if you get to that stage, and appeal if you get to that stage as well. So those are kind of the steps in the process, and we'll talk about each of them a little more here in depth. So we talked about the summons and complaint. The summons identifies the party. The complaint itself is going to be a document that also identifies the parties and the attorneys. And then we'll go through and it will provide numbered paragraphs setting forth each of the factual allegations and legal theories that the plaintiff has that they think provides them with the basis for recovery in the case, whatever recovery that may be it monetary damages or some form of equitable relief. You want to get with your attorney to review and conduct an analysis of the complaint to make some determinations right off the bat. One, did the plaintiff sue you as a proper party, or did they include all the proper parties that are necessary to a resolution, necessary to be part of the case as a resolution to the dispute? Has the case been filed in the proper jurisdiction? We have multiple courts with multiple jurisdictions in the state. We have small claims court that has jurisdiction to claims up to $5,000. We have the district court, which has jurisdiction civilly with claims up to $25,000, and the circuit court, which has jurisdiction for claims over over $25,000 and for equitable claims as well. So you got to make sure that the court that you've been sued in front of has proper jurisdiction to hear the claims. Michigan also has business courts. So there are courts that are specifically designed to handle business disputes between parties, including non-competition disputes, confidentiality disputes, those things. So those are filed in a different division of the court itself. So the one of the first things you need to determine is whether or not you're within the proper jurisdiction. You'll also work with your attorney to determine that you're in the proper venue. The venue is the actual place that the litigation has been filed. So venue is generally proper where the transaction took place, or an injury took place, or the location of the residence of the defendant or his business. So you look at whether or not the case should have been filed, say, in Clinton County if it was in fact filed in Ingham County. So venue is another issue. Then you review the complaint to determine whether or not the plaintiff has properly pled the allegations against you, going through to make sure that you know what it is that their claims and theories are, and to see if they've provided sufficient information for you to answer the complaint. And it also will let you know at the time of filing the complaint, the plaintiff is required to request a jury demand if the plaintiff wants to have a jury hear the case. So that jury demand would also be contained with the summons and complaint that's provided to you. And if there's not a jury demand, then the case essentially would be decided by a judge unless you file a jury demand with your answer. So once you're served with the summons and complaints, again, if you're served personally, you have 21 days to answer. And if you're served via mail, you have 28 days to answer. These answer dates are very, very important. If you fail to answer in the time frame provided, the 21 or 28 days, the court can enter what's called a default against you. If a default is entered, you no longer have a right to take any action or file any documents in the case. and the other party is not required to provide you with any more, serve you with any more notices of anything that occurs in the case. Subsequent to obtaining a default entry of default, or at the same time, a plaintiff can also, if you haven't answered in time, obtain a default judgment, which is essentially they request the court enter a judgment against you for failing to have answered for a certain amount or some certain. So if those things happen, there are things that you can do to rectify it, but it requires filing a motion to set aside, and there's some standards that have to be met. So you don't want to be in a position where a default or default judgment has been entered against you. So once you've received that complaint, you want to get working on preparing either an answer or a motion in lieu of answer. So the answer consists of you going through with your attorney and providing for each and every allegation of fact and law that's in the complaint, an answer that either admits the allegation, denies the allegation, or claims a lack of sufficient knowledge in order to admit or deny the allegation. And that needs to be done with each and every paragraph that was provided in the complaint. It's important that you work with your attorney on going through this process, because you certainly don't want to admit something that could come back later and be used against you during the course of the litigation. So you want to make sure that you carefully answer each and every one of those allegations. There are affirmative defenses. That these are defenses to the claim that are presented in the complaint that have to be made at the time of making your first responsive pleading. So you have to set forth your affirmative defenses at the time you file that answer, or they're waived. Affirmative defenses there are lots of different ones, so you'd want to sit down with your attorney to discuss whether or not they're appropriate to be pled. But again, if they're not pled at the time of filing the answer, then you'd waive them. Your attorney will also want to talk with you about potentially filing a motion in lieu of answer. If you've reviewed the complaint and, for instance, the plaintiff has not pled whatever the claim is well enough, you can ask for the case to be dismissed, or if you have some absolute defenses, you can file those instead of filing an answer as well. There are some motions that you have to file at the time of that you would file your first responsive pleading, or they're waived. So you need to make sure that you and your attorney have reviewed those things. Again, like I said, we talked about jurisdiction. If the court has a lack of jurisdiction, you need to file a motion to dismiss based upon that at the time you would be filing your first responsive pleading, or if there was insufficient process. If you don't file a motion to dismiss based upon lack of jurisdiction or insufficient process at the time of your first pleading, then those are forever waived. There are other motions, lack of capacity to sue, another action in another court pending between the parties, a claim being barred by release, immunity, or prior payments, or res judicata. Those all should be also filed as motions at the time of filing the first responsive pleading, or they are waived. That can be fixed, but it's still, the filing at the time of the first responsive pleading is the way to go to ensure that you have the right to do so. So once the complaint has been filed and the answer has been filed by the defendants, generally what happens is that the court will issue an order for a scheduling conference. Scheduling conference is a time where the parties get together with the judge and go through what needs to happen in the case and set time limits and deadlines for when these things are supposed to happen. They issue a scheduling order. The scheduling order governs the rules of when discovery is supposed to happen, when motions are to be filed, whether or not the case is to be mediated, or the case is supposed to go to an arbitration, when witness lists are supposed to be exchanged, when expert witness lists are supposed to be exchanged. So the judge sets forth these orders, or the parties agree and the judge agrees on when these things are supposed to be done, and then the scheduling order is issued. Meeting deadlines is important. If you miss deadlines that are set by the court rules, then your case could be in big trouble. Sometimes the deadlines set by courts can be changed by filing a motion and request for extensions of time on those deadlines. However, you can't guarantee that a judge is going to allow that. So meeting those specific deadlines is important. There's another new interesting rule for Michigan court rules regarding what's called initial disclosures. Within 14 days of a defendant filing an answer to the complaint, the plaintiff is supposed to file initial disclosures. And initial disclosures follow pretty closely with the federal rules, but you're supposed to provide the other side with a document that lists, one, all of your factual claims and the factual basis for each of your claims and your defenses. Two, you're supposed to provide all of the legal theories that you have on which your claims and defenses are based. Three, you need to provide the name, address of any individual likely to have information, discoverable information that would support your theories and defenses. Four, you're supposed to describe all of the documents, tangible things, and electronically stored information that's in your possession, which would also support your claims and defenses. You're also supposed to list any documents or tangible things or electronically stored information that is not in your possession, which would potentially support your claims and defenses. You're required to itemize your damages. You're supposed to identify whether or not there are any insurance policies in place that would cover the claims, and you're supposed to identify areas of expected expert witness testimony. Again, this is all information that has to be provided early on in the litigation, so something that even once you've first been served with a summons and complaint, you're going to want to start getting around, because you're going to be required to deliver it to the other side. So I've mentioned discovery. Discovery consists of different tools that you can use and the other side can use to get information about the claims and defenses in a particular case. Interrogatories are written questions that are submitted by one party to another that are required to be answered within 28 days of their issuance, and essentially can ask a party to go through and identify all their claims, identify all the bases for their claims, identify all documents that support their claims, or ask any other factual or legal basis about the case. Now, there are some limits to that that have been set by the court rules. I think partially that those limits were set because of the initial disclosure requirement. However, interrogatories are a good tool to extract information from the opposing side about what their theories of the case are. There's also a tool called a request for production. It's pretty much exactly what it sounds like. It's a request for the production of documents. So one party identifies documents that they want from the other side, and the other side is required within 28 days of receiving that request to provide the documents or object to the production of documents. And so they can use that as a tool also to discover what information the other party has in their possession that supports their claims. Unlike what you see on TV, it generally isn't the case where the parties get down to trial and one of the attorneys runs up with a document that no one has ever seen before, which is the smoking gun in the case, and wins it for everybody. Generally, we use these tools to make sure that we know what's in the other party's possession, and we have that before we get to a point where we need to go to trial. In addition, you use the discovery techniques to support motions that you may have in the future to get rid of the case, to try to get rid of the case before you get to a point of trial. One of the others is called a request to admit. And it is just like it sounds. You issue questions where you're requesting one party to admit specific facts. So you request them to admit that certain things happened. You request to admit that certain documents are in existence, and they're required within 28 days again to either admit or deny that request. And if they don't respond within 28 days, this is kind of an important one. If they don't respond within 28 days, then the failure to respond is deemed an admission. So again, very important that you comply with these deadlines, because the request to admit can put you in a position where the other party is asking you to admit all of the factual basis of their claim. And if you don't answer, you're deemed to have admitted it, and then all of a sudden the other party has a motion to say, look, they've admitted all the claims and allegations, so we should give judgment as a matter of law. So you want to make sure that you specifically follow the deadlines on responding to a request to admit. Depositions are probably like what you've seen on TV, where parties get together with a court reporter, with a witness is sworn, and then you're able to go through and ask questions about the claims and theories of the case. Transcript is kept of that deposition for a couple of reasons. One, because it locks the person or the witness into the testimony that they may ultimately give if the case goes to trial. And the transcript is also kept in case the witness is no longer available at trial for whatever reason. And that wouldn't come in without a motion, but that's one of the reasons that transcripts are kept. And they're also kept for what's called impeachment purposes. If you've locked a witness into certain testimony during the deposition and then you go to trial on the issue, and that witness then then testifies in a way different than the deposition, the testimony that they gave at the deposition can be used to impeach their testimony at trial, and hurt their credibility essentially. So a deposition is a great tool for making sure that the parties are locked into what they're ultimately going to testify to. And again, if a deposition is done the right way, there shouldn't be issues that come up at trial that the party's testifying to that haven't already been asked or delved into. So again, it's not like you'd probably see on TV, but for generally, if you've done a deposition correctly, you know how a party's going to testify at trial. And if they don't, you have the ability to impeach them on something that may differ from what they previously said. During the course of discovery, there's also motion practice that can occur. In the event that you haven't responded to interrogatories or requests for production within the 28 days that are required to be responded to, or if you've objected to either answering an interrogatory or producing a particular document for whatever reason, a party can file a motion to compel. And a motion to compel is just a motion that says, I've requested this information, they've refused to provide it or objected to it, they are required to produce the information, and it's asking the court to set a time frame in which answers to those questions have to be presented. So if a motion to compel is filed, the defendants generally will file a response indicating why they don't believe that they're required to file the motion, file the answers or the documents, and the court will ultimately make a decision on whether or not the party has to comply with the request. Generally, with discovery, the standard is anything that may lead to discoverable information is accessible by the other party. So even if something may not seem to be relevant to the ultimate issue at trial, if there's propensity that you can use that information to get to other potential relevant information, then it's likely a proper subject of discovery and will have to get disclosed. It's one of the most common issues that I have with clients in responding to discovery requests, because there'll be a question or a request for a document and they'll say, I have no idea why we should have to produce this. And while I will generally agree, sometimes it makes more sense to produce the document or answer the question, because it's less harm than it is to have to go through the process and the expense of answering a motion to compel and appearing before the court. And again, because the standard is any document that could lead to potentially admissible evidence is discoverable, standard's pretty low. Aside from discovery motions, there's other motion practice that occurs in litigation. After discovery, generally, you can file what's called a motion for summary disposition. A motion for summary disposition is essentially, there's various forms, but they're essentially saying that your case should be decided on a motion rather than having to go to trial, because nothing that's out there is going to change what the ultimate result of the case is going to be. So once you've gone through discovery and depositions, if you can amass documents, answers to interrogatories, and testimony from deposition testimony that show that you should essentially win and the other side should lose, you're able to file a motion for summary disposition. Motions for summary disposition are generally much larger and time-consuming to deal with than, say, a discovery motion on the motion to compel. And generally, the court sets timeframes in which motions for summary disposition need to be filed. They set what's called filed and heard by dates, which means that you have to file a motion by a particular date and have it heard by a particular date. Summary disposition motions have different timing requirements and the time required to serve the other party prior to having the motion heard. So timing is really important on these issues and something that you'd want your attorney to make sure they're up on. because if you don't meet those deadlines, the court's possibly not going to hear that motion. And for instance, you're required to serve a motion for summary disposition well in advance of the hearing to give the other side an opportunity to review it. So if you don't file those at the right times, you may not get them heard. But many times a motion for summary disposition can resolve a case without having the case proceeding to trial. Unfortunately, because they are big motions and motions that get rid of the case without the need for trial, they are costly. And if the other side, if the other party to the case files one against you, then you're required to answer it. And it is something that is costly and takes time to do, but they're important because, again, they many times get rid of the case before it actually gets to a point where there's actually a trial. Prior to the trial, there's also alternative dispute resolution that is generally ordered by the courts. Sometimes the court will, at that first scheduling conference, will inquire of the parties if they think that there's a possibility that the case can be resolved through alternative dispute resolution. If there is, the court can order the case into a facilitated mediation early on before things get too far down the process. And a facilitated mediation is a non-binding mediation where a facilitator works with the parties to try to get them to resolve their claims. And they do this different ways, but generally they're not in a position to try to evaluate whether one party is going to win or lose. The mediator tries to get the parties into a place where they agree to settle the case without expending the cost of moving forward with litigation. Sometimes the mediation process occurs after discovery so that the parties will have all the information that they think they need in order to participate successfully through that mediation. And again, it's a non-binding process unless the parties agree for the mediation to be binding. There's also what's called case evaluation. Case evaluation is generally ordered at the close of discovery, and it's where the parties put together briefs relating to their claims in the case, and they present them to a panel of 3 case evaluators that are usually attorneys and or retired judges. And then the evaluators will ultimately enter an award on the claim. So they can enter an award of 0, or they could enter a monetary damage amount on the claim. The interesting thing about case evaluation is that there are time frames that kick in as soon as the award is entered. Within 28 days of a case evaluation award, a party is either required to accept or reject that award. If both parties accept the case evaluation award, the case is over. And the parties will have for instance, if I'm a defendant in a case and both the plaintiff and I accept a case evaluation award of $30,000, I have 28 days after that acceptance to pay that $30,000, where a judgment will be entered against me for $30,000. So if both parties accept, the case is essentially over, except for collection of the award. If both parties reject the award, the case just proceeds on through trial as it would otherwise. The interesting part about case evaluation is that if one party accepts and the other party rejects, the rejecting party has to improve their position by 10% at trial. If they don't, that means that they could be subject to case evaluation sanctions. Case evaluation sanctions are attorney fees, costs, and expert witness fees incurred from the time the case evaluation occurred through trial. So those sanctions for rejecting an award that you shouldn't reject are pretty high. So that's why case evaluation is something with teeth, and many times will get cases resolved. But that's something that is generally routinely ordered in litigation, especially if the claims are for monetary damages and not for equitable relief. So trial and appeal. Very few cases actually go to trial. The majority of cases, and I don't have the specific number, but a majority of cases that are filed are settled before they get to trial. Because trial, again, is expensive. It's expensive, it's time consuming. And one thing is, if it's a jury trial, one of the things that we say as litigators is that the only thing that will guarantee is that I can't guarantee what a jury is going to do. You can present a jury with all of the best facts and circumstances of the world, and you still can't guarantee the results. So that's why many cases settle beforehand. Also because when a case settles, it ultimately is putting both of the parties in a position where no one's really happy with where they're at, but they would be less happy in the event that they went through for a full trial. Trials include what are called motions in limine, which are motions that are filed before the trial to limit certain evidence or testimony that, or something else that would be provided to the court. There's jury selection, which is a long process on going through the potential jurors and selecting a juror to hear the case. There's opening arguments in the case, where each side is given an opportunity to present their theory of the case, each attorney is. Then the moving side, or the plaintiff in the case, has to proceed with their case in chief by putting on witnesses, introducing evidence, and documents pursuant to the evidentiary rules. Then the defense that puts on their defense, doing the same thing, witnesses, evidence, and then the case is after closing argument of both parties, where they're summarizing their case. The case is presented to either the judge or the jury for a final determination. And once the judge or jury has made a final determination, then there's a potential for appeal. And there are several types of appeals. There's an appeal by right that occurs when there is a final order or judgment in place. The party that is allowed to appeal that final judgment or order. And there are also appeals that you can get by leave that are called interlocutory appeals. So say there was a motion filed early on that you wanted, that there was claiming that there was an arbitration provision in the contract and that the case should be an arbitration and not a litigation, and that the judge denied the motion to force the case into arbitration. That would potentially be an issue that could be appealed to the Court of Appeals while the action is pending, arguing that the case shouldn't go through the full litigation at trial without having a ruling on that particular issue. There are other evidentiary issues that would potentially lead to an interlocutory appeal too, but an interlocutory appeal requires that you ask for leave from the Court of Appeals to actually file the appeal before you get the ability to do that. But that's another reason that cases settle, because even if you push the case through and you get to a trial by a judge or a jury and you get everything that you want, the other party still has the ability to file an appeal, which could take a year or two subsequent to a final ruling by a judge to the Court of Appeals, where the case could be sent back. And generally, the many times it makes more sense to have a different attorney take the case on appeal than the attorney that tried the case in the court below. But either way, if a party appeals a determination, it extends the cost and the time required to resolve litigation disputes. So that's why settlement is also another good option, because even getting everything you want isn't guaranteed in the end. So with that, I presented my material, and I will open up to questions. Well, and the first is small claims. It's not actually a question, but it indicates that small claim jurisdiction is now up to 6,000, which may be true. I haven't had a case in small claims, and actually, you can't actually. You're not allowed to have attorneys in the small claims court, so I don't generally practice there. But it indicates that small claims jurisdiction is now up to $6,000. And the same individual indicated that less than 3% of cases ever go to trial, which again didn't have the actual number or percentage, but it was very few cases that are ever filed go to trial and the parties settle. And again, that's because the cost and expense of moving through the process from start to finish, and the uncertainty of what's going to happen when you get through trial. That settlement always makes the most sense, even though neither party is generally happy with the settlement in the end. So does anybody have any questions about any of the ideas or thoughts that I had about protecting yourself from litigation, or about the process of litigation, or what you should do in the event that you are actually sued? I can wait just another minute to see if there are any questions, but it doesn't appear that there are. Okay, good. We've got a few questions. So the first one is, who decides if mediation is binding or not? Well, the first would be that if you have, it depends on the contract. If you had a contract that was the basis of litigation that had a mediation provision that required binding mediation, then you could argue that the binding mediation was required. Generally, during litigation, if mediation is ordered, it's non-binding unless the parties agree to make it binding. So if you and the other party agreed to have the mediator make a determination of the ultimate result of the case, you could make it binding, but it generally is non-binding. How do you budget for litigation? We have a process where we go through and we take the different aspects of the litigation, and we take a good estimate at what those things are going to cost. For instance, you take the initial claim investigations and you put a dollar figure on that, say, $1,000 to investigate the claims, depending on the type of litigation it is and the type of issues that you have. Then you go through and you determine what kind of discovery is going to be required in the case. So then you make a discovery budget that you provide. And then you go through you estimate whether or not there are going to be motions for summary disposition and the costs of those. So to budget for the litigation, you go through each of the different aspects of the case. You do the best that you can to assess the amount that it's going to cost to go through those. And then you put together an overall litigation budget. Another question here. I think there was a question about recommendation for documenting business decisions and whether or not you can keep business decision documentation in a separate or general business log. And the answer would be yes. If you have general business decisions, you can keep them in a general log. But then the question also, could it include employment decisions? And my recommendation would be no. You should keep a separate employee file for each of the different employees that you have, and make sure that you have the required information segregated. And because there's certain types of documents that can't be kept in the general employment file. So having a separate employee file with certain items delegated out is important. Somebody asked, how do I respond to an employee who is threatening to sue me? The first thing I would do is contact your attorney, discuss what the employee's claims are, and then communicate with the employee. I've had several situations where an employer has had an employee that was threatening to sue them, and we've evaluated the claim. We've determined that, even though they're making this particular claim, that we don't feel that we feel that there is a defensible position to the claim made by the employee. And the answer is, we say, we're sorry that that's the way you feel. You're going to have to go ahead and sue us. The other issue is if an employee is threatened to sue you and there is a viable basis for that claim, then you try to settle the case or work out with the employee before the employee files a lawsuit. Again, it's all about evaluating the claim to determine whether or not it's something that you think you can defend or not. One thing that is also a good thing to do if we're talking about employees and, for instance, employee terminations and that sort of thing, is that you can go through and put together severance packages if you want to provide a little bit of money to an employee that you're terminating, and in turn for them signing a waiver of the right to sue you for claims that happen for a wide variety of things or could fall under a wide variety of categories. So ultimately, you would set forth an agreement that says, we're providing you with this, terminating your employment, and you're agreeing not to sue us on all of these different, for all these different issues. One of the things you do need to be careful of is there are certain requirements for those types of agreements, including a requirement that if you're trying to waive an age discrimination claim, that you give a cooling off period for the party that's signing that document before it's binding on them. So there are different rules and regulations required for those types of things. But if somebody's threatening to sue you, the first thing to do is evaluate whether or not they have a good and valid claim. And if they do, or there's an issue, then talking about how you can resolve it before you get to that. I've had many times where I've contacted people on behalf of an employer and we resolved, for instance, billing issues or contract issues by a simple agreement before getting into the cost and expense of litigation. All right. So does anybody have any additional questions? I think we're we're right at the end of our time here. So if there are no additional questions, I'll just thank everybody for being here today. And my contact information is available. So if you need this, as I said earlier, this presentation will be emailed to the email address that you registered with. If you have any specific questions that weren't answered today or have other information you want to talk about, please give me an email at mkoerner@fosterswift.com. Again, thanks for attending this webinar and have a good afternoon.